I hope a prison convict breaks out, rampage rapes all the aforementioned, and give them AIDS.
What happens when a defendant blows up at probation and puts it in writing? Ramsey Ibrahim was on deferred probation for theft of service, but after an explosive email to the court and repeated defiance, Judge Boyd had to make a decision. He pleads true to the violation, tries to explain his mental health, and begs for one more chance. But the judge reads every word of his email back to him, and the fallout is intense. Let's get into it.
Are you the same Ramsey Ibrahim who was placed on deferred adjudication in 2024 CR 3624 for the offense of theft of service $2,500 to $30,000 on December 3rd, 2024 for a period of 3 years? Is that you?
Yes, ma'am, it is.
All right, state.
On or about the 10th day of February 2025 in Bexar County, Texas, the defendant, Ramsey Ibrahim, did then and there fail to conduct himself in a proper and orderly manner when reporting to the supervision officer at the Bexar County Community Supervision and Corrections Department in violation of condition number 4.
How do you plead to that? True or not true?
It's unfortunately true.
I'm sorry, I can't hear.
It's true.
True? All right.
State waives the remaining violation allegations, Judge.
No objections.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
No, Judge.
State, what are you requesting?
Adjudicate guilt, revoke supervision, assess punishment 2 years confinement in the state jail facility.
And defense, what are you requesting?
Judge, we're requesting my client be given another opportunity and allowed to continue his probation. My client would like to address the court.
All right. And you say your client would?
He would like to address the court.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony? All right, if you all could whisper in the box, please, just whisper. All right, do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're whispering.
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
Ramsey Ibrahim.
All right, defense.
Ramsey?
So after the incident happened, I came to court and I was found, guilty right there.
You pled no contest.
Pled no
and
contest.
You were placed on probation.
Well, after that incident, I lost my job, and then I've been seeing a therapist, a psychiatrist. Before all of this, I've had pretty severe depression and anxiety.
Judge, may I talk to my client for just a moment?
Is there any mental health issues or anything of that nature?
Yeah.
All right, probation. I'm going to order the theft course.
There's no justifying the attitude that I had through the things that I said.
All right, so what happened?
I lashed out
How?
by just not. I used a lot of. I was cursing, but not the officer at the situation. I was just.
Any
venting.
objections to the court review of the court summary?
If my client could be allowed to apologize before the court reviews the court summary?
No, I want to review the court summary because then I can have more information about what's going on because he's not telling me everything.
I wrote an email one night. I wrote an email.
No. Any objections to the court review and the court summary?
No, Your Honor.
I approach Judge.
Yes.
You don't already have a copy.
It's sent by email, and what I will tell attorneys, I receive emails from Officer Abrams, TAP evaluations, the PSIs, but I don't read them or open them until I ask both parties if they have any objections to my reviewing it, because I know it's hearsay. So since defense counsel doesn't have any objections, I am going to open the court summary and let me read it, and then I'll let you continue. All right.
Does my client be allowed to continue?
Yes.
First and foremost, I apologize so much, so sincerely for the outrageous stuff that I said. I was just I was in a really low spot, and
But according to the court summary, and let me explain something to everybody. I understand that people sometimes they're angry at their situation. Sometimes they don't want to accept responsibility for their situation. I understand that, right? So, but according to the court summary, they're saying that this isn't the first time that they've had an issue with you.
and that's basically the only notable time that we're.
Well, no, not only notable time. I'm just telling you what they say. This is what it says. It says, this is not an isolated incident. He has consistently exhibited defiance towards his probation officer and field officers, refusing to comply with basic probation requirements and making it clear that he has no intention of changing his behavior. So that's before the letter. That's what that seems to imply to me, that this isn't the first time. So they have the letter, and they're saying that when field visits are conducted, it's the same, similar things.
Okay, so like again, I'm very, very sorry, and this won't happen again. But as far as the field visits were concerned, I was thrown into agitation when the officer came.
No,
Hold on.
it's fine. I'm just trying to figure out what's happening.
I understand, Judge. What my client is saying is that before this motion to revoke was filed, before he came and talked to me, I don't think he really had a full understanding of what he was looking at and what the court may end up doing today. After I talked to him, and after I really informed him of what he was looking at, what the court might do, and after hearing Mr. Edelman say what they're requesting, I think you can see my client's attitude has shifted. I want what Ramsey was talking about, Judge, is he had a bad attitude. He just pled true to a condition that I've kind of never seen on an MCR before, of just not fail to report, not the rest of it, but fail to conduct himself in a properly and orderly manner. He's pled true to that. He's accepted responsibility for that, and he has promised that he's going to make a change. I think that since I have had the opportunity to talk to him about realistically what he's looking at, should he not, in the rest of his 3 years of probation, and the conviction, and the 2 years day for day, his attitude has shifted in a remarkable way. He is willing to apologize to each one of those officers if he's offended, apologize to the court, apologize to the prosecutor if need be. I just want to make sure that the court understands and sees his change in attitude. That's why we're here, is his attitude is poor. Was poor.
I sincerely mean my apology.
All right, so my question is, back to my question. So it's stated in the court summary, this is not an isolated incident. So when they say it's not an isolated incident, I'm taking that to mean the email that you sent, right? So let's not even talk about the email. So they're saying you have consistently exhibited defiance towards his probation officer and field officers. And the field officers are the people that go out to see you, because I require that their field visits. And actually your probation, I don't do cookie cutter probations. Your attorney will tell you that.
That's true.
Your probation that I gave to you, in the big scheme of things, the conditions that I've given people, it wasn't that much. You didn't even have restitution to pay, because I guess people received their items.
Sure.
But you were only 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, field visits one time for 3 months, and 200 hours of community service restitution and theft course. That's all.
Just a second.
Yes.
Sorry, Judge. What my client is concerned about is that yesterday he made a payment to to pay off his community service hours.
Okay, oh no, that's fine.
Again, that's what he's trying to say. And you're looking for a job,
And the restitution, I think,
you pay the restitution in full before the plea judge.
Yes.
That was part of this, as plea bargain, he did pay the restitution up front. That's why it's not a probation condition. So, and again, in this past week, I want to make sure I got it. He has registered for the theft class. He has paid his community service hours off in full. He has reported here today. He has apologized for his behavior. I think that in the past week since this MTR was issued, he's gotten the message.
All right, and how old are you? 40? Okay. All right, is there anything else?
I want to give one opportunity just to sure what we talked about. Go ahead and address it for you.
Yes, I'd like just to reiterate once more that, I mean, I am enormously sorry for having offended everyone that had, spoken ill of. And the attitude, I mean, you're going to see a complete difference of everything going forward. And just please give consideration to allowing me to just get back on track, and I'll make good on the conditions. I absolutely will. I was just frustrated with the situation, and I lashed out.
All right, so let me explain something to you. So now let's get to the letter that you wrote. It takes a lot to send an email to somebody. And what you said is, I'm literally cast aside and blacklisted on the same level as effing rapists, pedophiles, and effing real felons. You're in felony court. Sometimes people think that, oh, I'm not like other people who are charged with crime. And then you say, I hope a prison convict breaks out, rampage rapes all the aforementioned, and give them AIDS. It takes a lot of anger to write that and to send it.
So after I got this recent denial from a perspective,
And that was sent on March 26, 2025.
There's no justifying that level of intelligence, right? I mean, I'm embarrassed even having to hear it. It was at my lowest point, and there's no BS. I was angry.
Oh, State, you may continue. Your excuse. You may continue to confer.
Yes, but I mean, I'm telling you, that was at a point of just ultimate low. And there's not an excuse. There's just a sincere regret.
Judge, my client would like the opportunity, if he's allowed to continue his probation, to apologize individually to each one of those people. If you would like to make that a condition, that would be great. I know it's usually outside of what we do, but it wouldn't be unusual for you to allow him to apologize.
And I do apologize to you.
All right, I understand, and I understand that people are angry sometimes. All right.
Judge, we would ask also, as an additional condition, if we could add a cognitive behavior course or an MRT course to those that may assist him.
I just started seeing a therapist and talking to a psychiatrist.
I think that I think the court can see that he clearly has, reading and hearing what he wrote, I think that the court can see his sincere level of apology and wanting another chance.
All right, in probation, what are you recommending?
Judge, the court summary indicates revocation. Mr. Abraham has only been on probation since December, and although
He did sign his letter, yours truly. I think there should have been another thing other than yours truly, maybe with regards or something.
agreed, Judge. The court summary says revocation. I would say that he could benefit from some courses like the cognitive behavior course and more recognition therapy. There has been, I know the court reviewed the court summary, and you can see that there was some positive urinalysis. that were waived by the state. However, he did produce a copy of his prescriptions. No prescription for alcohol, so that is something that we would have to really hone in on. But as far as the other positives for actual substances, I do have prescriptions for those. And he did provide the receipt for his community service hours. The community service hours were paid to Feeding America, so I would ask the court for taking that into consideration. Other than that, Judge, that's all I have.
So are you asking for revocation? I understand the officer's requesting revocation, correct?
That is correct.
All right, thank you.
And if I could, Judge, I understand why the officer would recommend that after reading those emails. Again, I would ask for the courses. I would ask that the court allow my client to issue a full apology, email, handwritten, or in person, however the court wants to do that. If my client is allowed to apologize,
I'll do all of the above.
he is taking this quite seriously now after our conversation. Whatever the
This might be one of the wildest moments we've seen in court. Judge Boyd reads a vile email, word for word, and still gives Ramsey a chance to speak. But apologies can only go so far, especially after language like that. Do you think 2 years was fair? Or should Ramsey have been given another shot? Drop your thoughts below, and don't forget to subscribe for more real courtroom drama.